Utah in 1992 with a BA in English, and from the University of Utah College of Law in 1996, where he was a William H. Leary Scholar and served on the board of editors of the Utah Law Review. Anyone who knows law school, if you're on the Law Review, you're pretty darn smart. But prior to joining Legal Aid Center, Jim was a partner with a large regional law firm where his practice focused primarily in the areas of commercial and corporate litigation, litigating disputes in both state and federal court, and arguing cases before the Nevada Supreme Court and the Ninth Circuit Court of Appeals. Jim joined Legal Aid Center in 2009 to open and manage the Civil Law Self-Help Center, Legal Aid Center's innovative, free, court-based resource center that acts as a legal emergency room, providing legal information, forms, and guidance to over 55,000 pro se civil litigants every year. And today, what he'll talk about a lot today is in March 2017, Jim took charge of the Legal Aid Center's Guardianship Advocacy Program, a new and expanding program that provides legal representation to the elderly and adults with disabilities who are facing or under guardianship. So please join me in welcoming Jim.
Good morning, everyone. Thank you all for being here. As Linda said, my name is Jim Berchtold, and I am an attorney with the Legal Aid Center of Southern Nevada, and I head up Legal Aid Center's Guardianship Advocacy Program. That program provides court-appointed attorneys to people who are facing guardianship or currently under guardianship. So, which is one of the new laws that was recently passed. Today, I'm not going to focus extensively on all of the legislative changes and all of the changes to the statutes, frankly, because it's super, super boring. So instead, what I'm going to do is give kind of a broad brush overview of guardianship and some things to really think about if you are considering applying for guardianship or if you are planning for avoiding, hopefully, guardianship in the future. So, what is guardianship? Guardianship fundamentally is the legal right to make decisions for somebody else. Now, what I say to my clients when I go out and I visit them, and these are clients who are facing guardianship, what I say is every adult has the ability to make decisions for themselves. They have the right to decide what medical care they're going to receive, how their money is going to be spent, where they're going to live, everything that we all take for granted every day. We have the right to make those decisions. Sometimes someone will go to the court and say, I want to make those decisions for this person. And if the judge grants it, basically, this person now has the right to make all of those, the legal right to make all of those decisions for you. So, it's serious business. It is one of the most powerful legal mechanisms that I know of in the law. In fact, it's so serious that scholars often refer to it as civil death, because basically, your civil rights are dying once you're under guardianship. So it is something to be taken very seriously. In fact, if you were sent to prison, you may have more rights than if you're under guardianship. So, a person facing guardianship can lose the right to decide where to live, the right to vote, the right to make healthcare decisions, the right to contract, enter into a contract and manage their own finances, and many other rights. So again, it's something that has to be taken very seriously. So what I first want to talk about is alternatives to guardianship. And you may ask, why are you talking about alternatives when we're here to learn about guardianship? Because the goal is to avoid guardianship if at all possible. And there are ways that that can be done. So you should always consider less restrictive means. These are a little bit out of order. Hold on. So, guardianship, why do you want to avoid guardianship? Guardianship is incredibly restrictive and incredibly intrusive. It's restrictive in the sense that there is a body, once you are under guardianship, there is a body of law that controls the decisions you can make as the guardian and as the protected person. It's intrusive because from that point forward, once the guardianship is granted, the court is involved in every major decision. Guardianship is also harmful to decision-making ability. So there are many studies that show that decision-making is like a muscle. The more you make decisions, the better you get at making decisions. Conversely, the less decision-making authority you have, the more you begin to lose the ability to make decisions. So it's never a favor to put somebody under guardianship because they tend to lose that decision-making ability. Finally, guardianship is also a lot of work for the guardian. Guardians typically think that they file the paperwork, they go to court, they get a hearing, and, oh, I won, I got the guardianship, my work is done. No, your work is just beginning. As I said, there is a whole body of case law that is now governing all of your actions. And every year you have to go back to the court and explain to the court what you did during the course of the year as the guardian. So, before you ever go down the guardianship road, always consider, is there some other way that I could address these issues without the necessity of a guardianship? And there are legal mechanisms to do this. There is, you can enter into and many of these will be discussed during the course of the day today. You can enter into a power of attorney, one for finances, one for health care. There's something called a representative payee if an elderly person or someone with a disability is having issues paying with their finances. There are trusts that can be constructed. There are advanced directives, living will. So the catch to all these things, though, the catch is they have to be done before the elderly person loses the capacity to do them. Once an elderly person loses capacity, they may not be able to sign a power of attorney. So what I am encouraging all of you to do is to plan for the eventuality that you may be in a position where guardianship is an option so that you can avoid it. Over 1/2 of Americans don't have the basic documents that make up an estate plan. I think that's from Forbes. I actually think that figure is a little low. So I am encouraging all of you to set up a plan while you can. A lot of the things that you can do to avoid guardianship, you can do without an attorney. It's really just signing your name and maybe getting something notarized. If you have a more complicated estate, you can always talk to an attorney to set up a trust or to make some other provisions. But so the takeaways I want from this first section, the takeaways I want you to leave with are guardianship is a last resort. It should never be the thing you think of first. It's the thing you think of if everything else fails. And 2, plan now while you can. And encourage your loved ones to plan. So now that I've told you why you shouldn't get guardianship, let's talk about guardianship. So types of guardianship. There are basically 3 types of guardianship, and those are guardianship. The difference between them is really time and the powers that the guardian gets. So a general guardianship is kind of the whole enchilada. It is unlimited. It lasts for the person's lifetime or until it's terminated. Usually, it would be terminated because the person regains their capacity. They get better and they don't need the guardianship anymore. There is a temporary guardianship, which is a short-term guardianship that's intended to address emergency situations. So think, for example, a loved one gets in a car accident, they don't have a power of attorney, they need an operation, there's no one to make that decision. A temporary guardianship can give somebody the power to make that decision for them. It's a short-term thing that is not intended to go beyond a specified purpose. There is also a special guardianship. A special guardianship is used when somebody is of limited capacity. That means they are able to make some decisions, but maybe not able to make all of their decisions. A special guardianship is for a particular purpose. So in the court's order granting the guardianship, it will specify exactly what the guardian is able to do. Guardianships can be of the person, of the estate, or both the person and the estate. So for example, a general guardianship could be of the person, or a general guardianship of the estate, or a general guardianship of the person and estate. Now, I will tell you that most people, when they file for guardianship, for some reason, they always say, I want a general, I want it of the person and estate, I want everything. It shouldn't be that way. It should be, I only want what I absolutely need, and I want the guardianship to be tailored to the specific issue that my loved one is having. So if you ever need to move for guardianship, think about how it could be tailored to address your loved one's issues. So what is the legal standard for a guardianship? When would a court actually grant a guardianship? Guardianships are granted when a person is incapacitated and the guardianship is necessary. A person is incapacitated under Nevada law if they are unable to receive and evaluate information such that they cannot make or communicate decisions about their own health, safety, and welfare. Now that has to be, in a guardianship case, that has to be supported by a physician certificate, where a doctor says, this is the condition, this is their inability to make decisions for themselves, they need a guardian. Now, but somebody can be incapacitated and not necessarily need a guardianship. You could be incapacitated, but the guardianship may not be necessary because you've already planned for it. You already have documents in place that allow somebody to make decisions for you. So in that case, a guardianship should not be granted because it's not necessary. Now, who can serve as a guardian? Basically anyone, for good and bad. Sorry, I'm just going to go through these. So there are essentially three types of guardians. There's the family guardian, which could be a wife, a sibling, it could be even a neighbor or a close friend. In my experience, that's the bulk of the people who move for guardianship. In the guardianship court, a lot of the cases are done pro se, meaning that the person is filing on their own behalf. There are also private professional guardians. Private professional guardians are companies that are in the business of being guardians. So this company may have multiple protected persons, which is what used to be called wards. Now they are called protected persons or proposed protected persons. So this company may have multiple protected persons, oftentimes that they have no relationship with at all. But typically, the person under the guardianship does not have a loved one who is willing to step up and take responsibility, but they have money, some pay source, that can pay the private professional guardian's fees. Now, if the person has no relatives and no money, that's when the public guardian comes in. The public guardian is the guardian of last resort. It is an appointed position, governmental position, and their job is to be the guardian when there's no one else to be guardian. Now, a guardian doesn't even have to live in the state of Nevada. So you could be a guardian if, let's say you lived in Utah. You could be a guardian for someone in Nevada as long as you have an agent in Nevada that is responsible. So there are special requirements if it's an out-of-state guardian, but it is possible. Now, in deciding who should be the guardian, the court has a laundry list of things to consider. In the statute, it sets out these factors among others. Can the person who's seeking guardianship, do they have the ability to provide for the basic needs of the person who will be under their care? Do they have a history of drug abuse or alcohol abuse? Have they been convicted of a felony, or have they been convicted of abuse, neglect, exploitation? Now, you would think that some of these things would automatically disqualify somebody from being a guardian, but that is not the case. The judges have immense discretion in deciding what they are going to consider and how they weigh those factors. So we have actually had cases where the person applying for guardianship is a convicted felon. They had been convicted of manslaughter and served a prison term. Nonetheless, the judge overlooked that and allowed them to be a guardian. So the judges have a lot of discretion. There is also a statute that says the order of preference a judge should consider. So the statutory preference is what you would think it is. It goes down the list of people that the law assumes you would want to act as your guardian. But I want you to notice the very first preference the court is to give is to the adult's request for who they want as a guardian. So later today, you're going to hear about the Secretary of State lockbox, where you can nominate a person to be your guardian and say, if it should ever happen to me, this is who I want to serve. Because if you don't do that, it can create fights in your family, and you may end up not only with a family member you don't want, but with a perfect stranger. So after the adult's preference, the list goes down in essentially the order that you would think it would. The spouse, the child, the parent, a relative. This is only part of the list. At the end of the list is a private professional guardian or the public guardian, ultimately, if there's no one else to serve. So I wanted to give you just kind of an overview of how a guardianship case moves through the court system. So a guardianship is initiated by filing a petition with the court and getting a citation issue. A citation is basically a document that says, we're holding a hearing on this time, and if you're interested in this, show up and be heard. So you have to get the petition, you have to get the citation. You also have to support those with a physician statement saying why the guardianship might be necessary, and you have to submit copies of the protected person's ID and your own ID. Now, once you have those documents on file with the court, you have to deliver copies of the documents to the relatives of the person who you are seeking to get guardianship over. You have to do that within the second degree of consanguinity. So that basically means the first degree is your parents and your kids. The second degree includes your grandkids, your grandparents, and your siblings. So all of those people have to be served with these documents, and all of them have the opportunity to come to court and say, I agree with the guardianship or I don't agree with the guardianship. Now, I will tell you, if you ever move for guardianship, if you ever try to get a guardianship, this is where people mess up the most. They say, well, Uncle Joe doesn't have really anything to do with my dad, so I don't need to serve them. Yes, you do, because if you get to court and they haven't been served, you're not going to get your guardianship. So ultimately, you will end up in a citation hearing. The citation hearing is where the judge hears everyone and decides whether or not a guardianship will be granted, so the judge will either grant the guardianship or deny the guardianship. If the guardianship is granted, the judge will issue what are called letters of guardianship. Those are actually the things that you would take to the bank, say, for example, if you wanted to open an account for the protected person. The guardian also has to sign what's called an acknowledgement of duties. The acknowledgement of duties is a laundry list, a multi-page laundry list of things that the guardian is responsible for. And the guardian has to go down and initial each one. Yes, I understand. Yes, I understand. Now, this is important because, as I said earlier, being a guardian is a lot of work and it's a lot of responsibility. Immediately after you get the guardianship, you have to do an inventory, which means you take stock of all of the protected person's assets and property. You inventory it and you file it with the court. You need to file a budget that says what are the protected person's anticipated monthly expenses, and you have to file a proof of a blocked account. Now, when you become a guardian, that money, the money of the protected person, is not yours. So there are mechanisms in place to try to protect that money. One of the mechanisms is a blocked account, meaning you would take all of the protected person's money, you would place it in a blocked account, which by court order, no one can access. The court order would say, every month, some amount of money will be released from that blocked account, and it will end up in an operating account, and that's the account that you can use to pay all the bills, for example. Now, we'll talk about the responsibilities of the guardian a little later, but this is important because it can get really complicated, especially for people who aren't familiar with this process or family members who are not used to thinking of your money, my money, our money. So, what are the duties of a guardian? So as I said, there are guardians of the person, guardians of the estate. In the statute, they're sort of divided up. If you're guardian of the person and estate, it's all your responsibility. So duties of the guardian of the person is responsible for providing food, clothing, shelter, proper training and education for the person under their care. They are responsible for authorizing medical treatment. So they are responsible for picking the doctor, taking them to making sure they get to the doctor, deciding what care they will and will not receive. They are responsible for housing the person, making sure that the person has safe and appropriate housing. Now, one of the recent legislative changes was change in residence and location. It used to be, before the statute got changed, that the protected person could be moved and nobody would know about it. Loved ones would go out to visit the protected person and they would be gone. So now there are additional requirements for change of residence, where if you change the residence of the protected person, you have to file something with the court and you have to notify the family. There are special requirements if the protected person is going to be admitted to a secured facility, meaning typically, say for example, a psych ward, something like that. There are also special requirements for visitation. It used to be that the guardian basically could carte blanche say who the protected person could associate with. No, I don't want you to see your brother. I don't think your brother's a good influence on you. That is no longer the case. Now, the assumption is that the protected person can see whoever they want to see. And the guardian can't restrict that unless they go to court and have the judge agree that the restriction is appropriate. The guardian of the person also has to file an annual report. So every year, the guardian of the person has to fill out a report saying what happened during the course of the year. What medical care did the protected person receive? What activities did they engage in? Who did they visit? What's their condition? Do they still need a guardian? If so, why do they still need a guardian? That has to be filed with the court every year. The other responsibility of the guardian of the person, if it appears with substantial certainty that the protected person is going to die, the guardian of the person is responsible for sending out a notice of impending death, which basically notifies all the family that this person may not last very long, and so you need to make whatever arrangements you need to make. So duties of the guardian of the estate. As you might imagine, the overall duty of the guardian of the estate is to protect and preserve the assets of the protected person and utilize those assets for the benefit of the protected person, to make sure they're conserved and to make sure they're, to the extent possible, extended so that they can care for that person for the rest of their life. So the guardian of the estate, as I said, initially takes all of the protected person's assets and inventories them and manages them. Now, a lot of those things that may sound fairly simple, but keep in mind, the court is involved in any major decision you're going to make. So as the guardian of the estate, if you decide that it's probably a good idea to sell the protected person's home, you can't do that on your own. You have to go to court, file a bunch of documents, and eventually maybe the court will give you permission. Same thing with things like investing. I want to invest the protected person's money. That's not your decision, that's the court's decision. So you have to file something with the court and get permission. The guardian of the estate, while they have a lot of responsibility, a lot of actions cannot be taken without court permission. Every year, the guardian of the estate has to file an annual accounting, and that accounting has to be set for hearing in front of the judge. The annual accounting has to specify every penny that comes into the guardianship estate and every penny that goes out of the guardianship estate. So all expenses during the course of the year have to be tracked, and they could be challenged if they're not reasonable. In fact, my job is to look at those expenses. Riley's job as the court compliance officer is to look at all those expenses, look at those budgets, and see if there are any issues. That's why it's important that all accounts should be maintained separately, and the guardian always has to keep in mind, this is not my money. So, if you have been in Nevada for any length of time, you have probably heard that a couple of years ago, guardianship in Nevada was a mess. It was a mess. There were a number of investigative reports that, exposés that brought to light abuses especially by private professional guardians, some of whom are now sitting in jail. Because of that, as Linda mentioned earlier, the Supreme Court put together a guardianship commission that really came up with some recommendations for best practices in guardianship. And as a result of that, there were major legislative changes. So I wanted to highlight a couple of major legislative changes that went through. The first is the Protected Person's Bill of Rights. Now, this is really what I see as kind of like the crown jewel of the legislative reforms. Very few states have them, But it's incredibly important because, as I said, it used to be that once you were under guardianship, your rights were gone. This is saying, no, that's not the assumption. The assumption is you retain your rights to the extent you can. So some of the rights that, this is only a small portion of the Bill of Rights, but the Bill of Rights says, I have the right, if I'm under guardianship, to be educated about what that means, to be educated about the guardianship, to ask questions about the guardianship, and if I have concerns about the guardianship, I have the right to express concerns. I have the right to receive court documents. It used to be that someone would find themselves under guardianship, and honestly, they wouldn't even know that there was a guardianship case. They never appeared in court, they didn't receive any documents, so now they have the right to receive all those documents. They have the right to participate in developing a plan of care for themselves and for their money. They have the right to have their desires and preferences given consideration, especially with respect to where they live, who they see. They have the right to remain as independent as possible for as long as possible, and they have the right to receive telephone calls and visitors. They also have the right to be treated fairly with dignity and respect. Now, you would think that this would be a given, and it shouldn't have to be in a legislative Bill of Rights, but that is not the case, so it is in the Bill of Rights. And as a guardian, you need to be extremely aware of what that Bill of Rights says. When I go out to meet a client, I leave a copy with every client and read through it with them and make sure they understand it. Because if a guardian violates this Bill of Rights, there is a private right of action attached to it, meaning that they can be sued for that violation. The other crown jewel in the legislative reforms, in my humble opinion, was the right to an attorney. So it used to be that a person under guardianship had the right to hire an attorney if they wanted to, but that almost never happened. So now, every person who is facing guardianship will get an attorney. When a guardianship case is filed, the case is referred to our office, and an attorney is assigned to them. Now, it's often unclear to people what the role of the attorney is. The role of the attorney for the protected person is just like any other attorney. My job as that protected person's attorney is to listen to what they say and advocate for what they say and try to achieve what they want. So prior to this, oftentimes the one voice that wasn't being heard in the guardianship case was the protected person. Everybody was talking about the protected person and what they thought was best for the protected person, but no one knew what the protected person wanted, and frankly, nobody cared. So our job is to protect their due process rights and their statutory rights. Even we will go out and meet with clients who, frankly, are unable to direct us. They might be in a coma. That doesn't mean they're not entitled to have their rights protected. So we stay in the case and we protect their due process rights, their statutory rights, and basically make sure the court is doing what the court should be doing, the guardian's doing what the guardian should be doing, and no one is taking advantage of the most vulnerable person in the room. We also will recover assets. If the guardian, which does happen, if the guardian has improperly taken assets or third parties have taken assets, we will initiate court actions to get those assets back into the guardianship estate. We will object to the guardianship if that's what our client wants. We will object to the guardianship. We will object to who is serving as guardian. Whatever our client wants, that's what we will advocate to the judge. Doesn't mean it will win the day. Obviously, there's somebody on the other side who is arguing something else, and the judge will ultimately make the decision, but at least the protected person's voice is heard. So now I'm going to give you, so that's a very broad brush overview of guardianship. I'm going to give you some resources if you want some additional information, where you can go to get that additional information. First, there is at the family court, which is on Pecos and Bonanza, there is a self-help center, the Family Law Self-Help Center. There is also a website that has all of its resources on there. On the website, there is a lot of information about guardianship. Also available on the website for free are all of the forms you would need if you should ever have to get guardianship over someone. Those are also available for free at the Self-Help Center. If you go to the Self-Help Center, you can get the forms for free. Now, as Linda said, these, part of what the Guardianship Commission did recently was totally revamp all of the forms. So the forms are now good statewide. So you can use these forms in any court in Nevada and they should be accepted. There is also a free community education class on guardianship. Should you need to obtain guardianship over someone, you can attend a class that is sponsored by Legal Aid Center and the Boyd School of Law. It is offered every week. The class provides you a nice reference manual and it walks you through step by step how you go through the court process of obtaining a guardianship. The class schedule is available on our website, which is www.lacsn.org. Finally, a shout out to the organizers here. I went on their website and www.aarp.org, and there's a lot of information on guardianship on that website and a lot of interesting articles that would be a great resource. So, takeaways from today. Guardianship is serious business. It should be the last resort if everything else fails. It's a big responsibility and it should not be taken lightly. Guardianship can only be granted when it's necessary and when the person is incapacitated. It is not an estate planning tool. It's a tool that's used when nothing else works and the person really needs some help. You can have guardianship over the person, the estate, or both, but whatever the guardianship is, it should be specifically tailored to the issue your loved one is having. It should not be broader than is necessary, because as I said, the broader the guardianship, the more that person loses their ability to make their own decisions. Even if a guardianship is granted, the adult still retains their rights. There is a protected person's Bill of Rights in Nevada, and just because they're under guardianship doesn't mean they have fundamental due process rights just like everybody else in this room. So that was my broad brush overview of guardianship. I am happy to take any questions anybody has. Hello.
I want to say that your center at the Justice Center, those people are fantastic. I had to use their help for a small claims matter, and then I had to go back and resubmit it because I won and get the paperwork and all that stuff, and they were just wonderful.
Thank you. Thank you.
Wonderful. I have two questions. My first one is that you had mentioned every family member needs to be contacted when you're putting this paperwork together?
So it's every family member within the second degree of consanguinity, which means parents, children, siblings, grandchildren, grandparents. So within that second degree around the person, all of those people have to be notified.
Okay, and then the other one I was concerned with, I know about the changes in the guardianship. I followed it for a few years. I was really astonished at what was going on. How did that ever get created here in the state of Nevada, and how long was that in existence?
So that's a great question. And interestingly, my boss, Barbara Buckley, who used to be the Speaker of the Assembly here in Nevada, she is actually in Washington, D.C. today testifying in front of the Senate Commission on Aging on the subject of guardianship. Because Nevada, unfortunately, has often been held up as the poster child for horrible guardianships. How did it get that way? I wasn't practicing guardianship at the time, but I think part of the problem was just lack of resources. The other problem was lack of oversight. On the court's part, the court would often, if something had come before it and nobody was objecting, the court would just grant it. Well, of course nobody's objecting because the person who would object is stuck in a home somewhere. So that was part of the problem. The other problem is there developed this weird relationship between medical providers, private guardians, and attorneys, where everybody was making money, so nobody's gonna rock the boat, because they're all making bank. And so all of this kind of played in together just to create a really, really bad situation. So, now Nevada is really on the forefront with all the legislative changes that went into effect. We have some of the most progressive statutes in the country and are often held up as the poster child now for good guardianships. So hopefully that will remain the case.
Thank you. Very good. Quick question. Oh, my name is Mark Curtis, and I'm a volunteer, and I also am involved with Medicare and Medicare sales. So I relate a lot of this to my clients, make sure they know about it. And in setting up in a situation where a family or somebody's setting up a guardianship, if you are going to have separate persons doing the person side and the estate side, can that be done in the same process, or does that have to be two separate filings?
No, it could be done the same. When you file a petition for guardianship, you can have co-guardians. And so multiple people can be appointed as guardian at the same time. And you could specify in there that you want one to serve as guardian of the person and one to serve as guardian of the estate. That's actually fairly unusual. Usually if you're going to do co-guardians, you give them co-extensive powers and then they can split it up however they want. But it is possible to do it in one petition.
Thank you.
Yeah, happy.
Hi, you touched on this a little bit earlier, and my question has reference to choosing the guardian if the guardian is from out of state, in other words, from another country. What are the steps or what are the pros and cons regarding that? Because sometimes the person needed a guardian is also from another country, and he would choose someone that could speak the same language, for example, or have the same culture. And that's basically what are the steps necessary in order for that person to be here more or less permanently, as long as he's being taken care of.
Well, so are you talking about someone from another country who will
Being chosen as a guardian, yeah.
Okay. So I don't know whether that's possible. The statute says that somebody from a different state can. I don't know whether somebody from outside the country could. Theoretically, I guess it is possible. I don't know. I would have to look at the statute. But I will say generally, out-of-state guardians are not great because a guardian has to be really involved in the person that they're charged with protecting. So under Nevada law, you can be an out-of-state guardian, but you have to appoint an agent here. But that agent could be an attorney. It's not somebody who knows the protected person or goes out and visits them. And so there's a difficulty relaying information about the protected person to the guardian who lives out of state, or the protected person's often traveling interstate, but they're going to charge that against the protected person, so that's draining the protected person's bank account. So it's not a great situation. I've seen it work, but I've also seen it really fail.
Okay, thank you.
You're welcome.
I'm Judy Mason, and you may have partially answered the question. I'm in the process of redoing all of my documents since I've come to Nevada. Right now, everything as far as my executor, second executor, et cetera, is a person that lives in Washington State. And you mentioned about having an agent in Nevada. Now, do I get to choose that with someone else? I mean, let's say going home, I get in an accident and I'm unconscious. You can't reach that person. You might not even know about that.
Right.
So what do I do in that case?
So we're kind of talking about two different things. If you put together estate planning documents, you can say anybody you want. In your powers of attorney, they don't have to be in Nevada. They could be anywhere. If you're going to do a guardianship, the guardianship laws require that there's an agent in Nevada who can be responsible. Now, from a really practical perspective, does it make sense to designate somebody as your agent under your power of attorney who lives in another state and who nobody can access? Maybe not. And the issue of how would people know that is always an issue. They're going to talk about later today about the lockbox, which is a great tool, but you should always make sure that your loved ones know who your designated agents are. Who has the power under the power of attorney? Where are all these documents? That's always something you should think about.
Okay, thank you.
Hi.
Jerry Lambert. I'm a volunteer with the AARP. Jim, thanks for the great presentation, by the way. It's great to see that Nevada's on the forefront of this. I'm pretty excited about that.
I agree.
A couple of questions, and probably you're going to answer these as time goes on, but I just want to make sure they're going to be covered. You talked about some alternatives like durable power of attorney, representative versus payee, trust, and advanced directives. Are those going to be part of the conversation later today, presentations?
Yes, there is somebody who is specifically giving a presentation on powers of attorney, and Valerie actually does some work for our office as well. She is going to be giving a presentation on trusts.
Okay, thank you.
Hello.
Good morning. My name is Ruth Hudson, and I have two questions for you. Are you or is anyone else going to be speaking about living wills and how that should, or does it take precedence over guardianship? So if you've already got a living will and everything is already laid out, is that?
So let me address that in two ways. There is somebody from the Southern Nevada Senior Law Program who is going to be talking later, and I'm not sure whether they will be addressing living wills or not. I think they might be. But the second part of that is, if I have a living will, does that mean nobody can get guardianship over me? No. They can go to court and they can say, I still need a guardianship. But if you have a living will, my response as your attorney would be, no, there's no guardianship needed because she already planned for it. So somebody could try, but it hopefully wouldn't be successful. So is it a guarantee that if I have a living will, you won't get a guardianship? No, but it's a pretty good indicator.
Okay. Second question. So let's say that the financial angels have smiled down on me and I have tons of money.
I would say good for you.
And I plan on spending every penny of it before I
good.
go.
Good for you again.
So, but in the event that that doesn't happen, if I need a guardian at some point and the person who is going to be or who wants to be the guardian does not want to handle that financial piece, does Nevada have public administrators that would be able to handle the financial piece only?
So the
court-appointed public administrator.
You can do that, yes. There are financial institutions in Nevada that handle people's money. So I have been in a case where the court has basically created a trust and appointed a trustee inside the guardianship case so that the court-appointed trustee can manage the person's funds. So that could happen.
But I mean, not a financial institution that is outside
no.
of the court. So
No. Oh, sorry, go ahead.
Okay, I did this in Denver, and we had a public administrator that would be appointed by the judge to oversee the financial piece.
I don't know.
As opposed to an outside entity.
Right. I don't know of any public administrator in Nevada that is charged with that responsibility. The public guardian does handle people's finances, but it's when there's no other option. And certainly if you have an extensive amount of money, that's probably not how you would want your money managed. So the better solution would be to create a trust so that you can say who's going to manage your money. And that could be a financial manager, that could be a friend, that could be a banker you trust, that could be anybody. And it would be smarter to set that all up before guardianship is even on the horizon.
Okay, or spend it now.
Spend it now. Great option. Casino downstairs. Yeah.
Hi, I'm Leslie Kim, FightFraudAmerica.com, and I want to know first, when was the new system put in place, date-wise?
So it happened over a couple legislative sessions. In 2015, one of the first laws went into place, and that was a law that required that private professional guardians be licensed. So they have to be licensed, they have to register with the state, and there's now a governmental entity that monitors them. That was one piece. The bulk of the changes to the statutes went into effect in 2017.
Okay, you mentioned before that there were individuals who had abused this system and were in jail. I'm aware of some of those. Was there any money set aside to dig in and recover assets for those people that were caught up in that, or are they just SOL?
Unfortunately, probably SOL. So a private professional guardian now has to have a bond. So there is some pool of money out there. If something goes wrong with the finances, there's a pool of money out there that you can go after. Now, the bond wouldn't cover a lot, but there is some option. Before 2015, there was no requirement to be bonded. So, for example, April Parks, you might have heard of.
That's exactly who I was thinking about.
She, when the crap started hitting the fan, she immediately declared bankruptcy. She has no funds. We've tried to get after her funds. She has nothing. I don't know what she did with the money.
She has a lot of relatives. and you know, it's obviously there is money there that is offshore, that is under other people's names.
There's got to be somewhere.
Yeah,
Yeah, so far that no one has had any luck recovering anything. And I think that's probably the case with most of the bad guardians. We have had some luck actually recovering from family members who did some really bad things, but I haven't seen a lot of luck recovering from the private professionals.
Okay, thank you.
You're welcome.
We have time for one more question.
Sally Como. Is there a difference between being an advocate or guardian?
So an advocate, there is a statute in Nevada that says that a program can be developed where lay people, non-lawyers, can be guardian ad litems, which are basically the eyes and ears of the court. The guardian ad litem would go out and check on the person and report back to the court. So that is really the only role for someone other than the lawyer and the guardian. There is nothing under Nevada law called advocate. Okay. Other states do have advocate programs where an advocate, who could be an attorney or who more typically is a non-attorney, would come in and advocate for what the protected person wants. I think with the changes to Nevada laws and now having an attorney for the protected person, maybe it has diminished the role, potential role of any advocate, because now that's exactly what the attorney's doing.
Okay.
Great questions.
Thank you, everybody.
I want to thank Jim for his presentation, for his time today. Obviously, I mean, you'll see as our speakers go through, we have really smart, high-quality people here that usually spend their day in court, and they've taken their day and given it to us. So I want to say a big thank you to Jim, and I know you're gonna probably leave before the end of the day. So I have something for you as a thank you from AARP.
Thank you.
I was hoping my state director could do this, but I know you guys are dispersing at different times. So thank you again.
I appreciate it.
And now we actually have time for a break. We're gonna serve you boxed lunches, but we're gonna, you can